Okay, so we're diving into some fascinating stuff today, talking about UK law and how judges sometimes actually make law,
Yeah, it's this whole thing called judicial precedent, common law.
the whole shebang.
Exactly. And what's so interesting is it didn't exactly start out organized, you know?
Oh, I bet. I mean, we're talking centuries ago, right? What was there, like a royal decree about, I don't know.
Think even before that.
Oh,
Imagine England before the Normans came in. You basically had this patchwork of local customs, like each village had its own little legal world.
oh, wow. So talk about a legal free-for-all. What happened if you had a dispute with someone from a different village over, like, I don't know, a cow or something? Whose rules won?
You're exactly right. It was a mess,
Hmm.
which is why the emergence of common law in the 11th and 12th centuries was such a big deal before that chaos.
I can only imagine. So how'd they go from that to, well, a system that still influences things today?
Well, that's where something like the Doomsday Book comes in. You might remember it from, well, history class.
Okay, yes. William the Conqueror's big project. It was a record of, like, who owned what land, right? But how does that tie into a legal system?
It wasn't just about land ownership. The Doomsday Book also recorded these local customs, which, believe it or not, often were the law. So you have these traveling judges.
Those early administrators of justice riding around on horseback.
Exactly. And they use this information from something like the Doomsday Book as a starting point for their decisions, trying to find some consistency.
It's amazing to think about these judges gathering information from the Doomsday Book. So they were literally riding around, listening to these disputes and trying to apply what? Some common principles from these, like, scattered local customs. Sounds more like an episode of historical drama than a law lecture.
It really does.
Hmm.
But those early rulings, those attempts at finding common threads, well, they became the foundation for a more unified legal system. And here's where it gets really interesting. They started documenting these decisions, the rulings, the reasoning behind them, and these records were shared.
Shared among these judges as they went from place to place. So wait, those shared stories, those early judgments, essentially evolved into the UK legal system as we know it today. Talk about the power of storytelling.
And that principle, deciding cases based on those previous rulings, that's the essence of stare decisis.
Okay, and remind me again what that means.
It's Latin for let the decision stand. Basically, prior rulings, they carry weight. It's still a cornerstone of common law today.
So what you're saying is what happened in, say, a 13th century sheep stealing case could still, in theory, influence how a judge rules on a copyright dispute today.
You got it. Now, of course, the legal principles, they've evolved over time, gotten refined, but that core concept, it remains.
That's wild. So it's like each case, each judgment adds another brick to this legal structure.
Exactly. A legal edifice built brick by brick. But, and this is important, not every court decision is created equal.
Right, because we have this whole hierarchy of courts, right?
Exactly. And that's where the binding part of precedent comes into play. The UK court system, think of it like a pyramid. At the very top, you have
The Supreme Court, the ultimate authority.
exactly. And their rulings, they're binding on every court below them. So let's say the Supreme Court issues a judgment on, oh, I don't know, what constitutes cruel and unusual punishment. Every other court that handles a similar case after that, they're obligated to apply that interpretation.
That makes sense, keeps things consistent. But what about those areas of law that haven't been specifically laid out by Parliament? You know, like those little crumbs left on the legal plate? What happens then?
Ah, yes. Those are fascinating because that's where judges have more interpretive leeway. They look to previous cases, but they also have to apply the law to situations those old laws might not have even imagined.
Okay, yeah, give us an example. What's something that's only partially defined by actual written law?
Take something like the concept of nuisance. There are some written statutes about it, but a lot of it is rooted in common law, in how judges have ruled on similar cases in the past.
Okay, so let's unpack that a bit. What does that mean for, say, I don't know, a local council dealing with a noisy all-night chip shop? Is there a law in the books about late-night deep fryers?
Probably not. But there might be established case law, you know, precedents where judges have ruled on what constitutes a nuisance more broadly. Maybe considering things like time of day, location, how bad the disruption is.
So, like, if the chip shop is right next door to a hospital, that's one thing. But out on a busy street, maybe it's different.
You got it. These precedents, these past rulings, they become super important in those gray areas where the law isn't totally cut and dry.
So the council's legal team would be digging up those precedents, saying, look, based on all these past rulings, this chip shop is in the wrong.
Exactly. though the chip shop's lawyers would be doing the same thing. And this is crucial, trying to argue that this case is different enough from those previous rulings to warrant a different outcome.
Because, let's be real, no two cases are the same.
Precisely. And that's where the concept of distinguishing comes in. The chip shop might say, hey, our fryer is state-of-the-art, super quiet. Or, people have been complaining about the noise for years and the council hasn't done anything, so they've created a precedent of their own.
So it becomes this legal chess match, each side using precedent to build their case, but also trying to highlight what makes their situation unique. And the judge has to weigh all of that.
That's exactly what makes common law so dynamic. It's constantly evolving through these interpretations, always adapting.
It's not just what the law says on paper, but how it's been understood, applied in the real world, which, let's be honest, is rarely neat and tidy.
Precisely.
It makes you wonder what those early judges, those horseback riders with their copies of the Doomsday Book, would make of the legal questions we're dealing with today.
Right, from sheep stealing to, international copyright disputes in the digital age.
Exactly. But before we get too far ahead, let's actually dive into some real-world examples to really illustrate how this whole precedent thing plays out.
Oh, absolutely. Seeing these principles in action is really going to bring this whole concept to life. Okay, ready for a real head-scratcher? Picture this. It's 1872. A man is stopped by the police for riding his bicycle right down the road, his offense. Riding a carriage on the public highway while intoxicated.
Wait, hold on. They tried to call a bicycle a carriage? That's some creative lawyering right there.
It does, doesn't it?
Yeah.
But it highlights how judges have to adapt existing laws to new situations. The law in question was the Licensing Act of 1872, and it didn't specifically define carriage.
Oh, I see. So they had this brand new invention, the bicycle, and they're trying to make it fit into a law that's probably talking about, what, horse-drawn carriages. What did the judge decide?
Well, in this case, the judge actually ruled that a bicycle could be considered a carriage. It's a great example of what we call ratio decidendi, the reasoning behind a judgment that becomes binding on lower courts.
So it's not just the decision itself, but the why behind it.
Exactly. Otherwise, every judge could just interpret things however they wanted. And the why, in this case, is pretty interesting.
Okay, lay it on me.
The judge basically argued that the intent of the law, the whole point, was to protect people from, drunk people operating vehicles. The potential for harm was basically the same, they figured, whether you were on a horse-drawn carriage or a wobbly bicycle.
So they looked beyond just the dictionary definition of carriage and thought about what the law was actually trying to do, which, makes you wonder what those 19th century lawmakers would make of our modern roads. Cars, buses, those electric scooters zipping about.
It's remarkable, isn't it?
Yeah.
But that's the beauty of this system. It can evolve.
Exactly. Now, I have to ask, what about those times when a judge encounters a past ruling, a precedent that just seems, flat out wrong, maybe outdated or even unjust by today's standards? Can they just disregard it?
That's where things get even more interesting. You see, sometimes a higher court might decide that a precedent, even one that's been around for ages, was wrongly decided in the first place.
So they can essentially overturn it, hit the reset button.
It's called overruling, and it's a key way that common law corrects itself over time. A perfect example is Wilmington v. DPP from 1935.
Okay, 1935, hit me with it.
So we have a man named Wilmington. He's accused of murdering his estranged wife.
Always the estranged wife.
Right, but he claims it was an accident, said the gun went off unintentionally.
Okay, but how do you even...
Well, here's the thing. Under the law at the time, the burden of proof was essentially on him to prove his innocence.
Wait, seriously, that seems backwards. Don't we have this whole innocent until proven guilty thing?
You're telling me. But back then, the law wasn't so clear on that point, at least not in murder trials.
So what happened?
Wilmington was found guilty, sentenced to death.
Oh, man. That's awful, this poor guy, to have to prove that you didn't do something.
It's a huge weight to carry. But here's where it gets really interesting. The case, it goes all the way up to the highest court at the time, the House of Lords, what we now call the UK Supreme Court.
Oh.
And they overturned the lower court's ruling.
They said, hold on, this isn't right.
Exactly. They basically said, in a criminal case, the burden of proof, it lies with the prosecution. It's up to them to prove guilt beyond a reasonable doubt. The defendant doesn't have to prove innocence.
Wow. It's amazing that such a basic principle wasn't always, set in stone.
Right. But it shows how important judicial precedent can be. Wilmington, that case, it established a precedent. And it changed how criminal trials were conducted from then on.
That's incredible. So this idea, the prosecution bears the burden of proof, it all stems from this one case.
That's the power of precedent in action. And
Yep.
speaking of Wilmington, that case is a great example of how ratio decidendi and obiter dicta can exist within the same judgment.
Okay, remind me again, what's the difference? It's like those legal terms, they sometimes slip my mind.
Right, so the ratio decidendi, that's the binding part, the core reasoning, the thing that lower courts have to follow.
The main course.
Exactly. And then you have obiter dicta. Those are like additional remarks, observations the judge might make along the way. Insightful.
Hmm.
Maybe. Potentially persuasive. Sure.
Yeah.
But not the main event, not the thing that's binding.
Got it. So in Wilmington, the precedent that matters most is that the burden of proof lies with the prosecution.
You got it. But the judges, they also discuss the history of the burden of proof, how murder and manslaughter laws developed over time.
Interesting, but not something a lower court would be bound to consider in a future case. It's like those bonus features on a DVD, right? Interesting context, but not essential to the main feature.
Exactly.
It makes you think about those law students, those legal professionals. They have to sort through mountains of case law,
Yeah.
trying to figure out the ratio from the obiter.
It can get pretty dense, that's for sure.
Talk about a needle in a haystack. So it's not just about knowing the cases, but really understanding the arguments, the context of the rulings, how they all relate to each other.
Exactly. It's about connecting the dots, seeing the patterns.
It's a bit like detective work, isn't it? Piecing together the clues. But speaking of cases, you mentioned earlier one involving, what was it, a disqualified driver. I'm curious about that one.
Yes. That's a good one. It really shows how judges use this idea of distinguishing to deal with those situations where the law isn't exactly clear-cut.
Okay, so that disqualified driver case. Let's hear it. What happened there?
So picture this. You've got this guy. He's found in his car. It's parked at the side of the road, and he's intoxicated.
Okay, sounds like an open and shut case. But there's a twist.
There is. He wasn't actually driving when they found him.
He was passed out in a burger joint parking lot.
Not quite. He was asleep in the driver's seat. Keys were in the ignition.
Okay, so not driving, but...
But he was charged with being in charge of a mechanically propelled vehicle while unfit to drive because, well, he was intoxicated.
I see. So it's a bit of a gray area. He wasn't driving, but he could have driven. How'd the court see it?
That's where this distinguishing thing gets really interesting. The court had to look at the specifics of this case. Did they warrant a different outcome, even if he technically met some of the criteria of the law?
Right, because like we've been saying, no two cases are exactly alike.
Exactly. Now, there were previous cases where being in charge didn't require someone to be literally driving. Like, even trying to start the car had been enough in some cases.
So the court had some wiggle room.
Right. And in this case, the man argued that he'd moved his car a short distance earlier just to park it safely. He said he had no intention of actually driving any further because he knew he'd been drinking.
Interesting. So what happened?
The court actually agreed to distinguish his case.
Yeah.
They found him not guilty of the offense.
Wow. So even though on paper he met some of the criteria of the law, the specific details mattered.
It's a great example of how judges have to consider not just the letter of the law, but the intent behind it.
To ensure a just outcome.
Exactly. And that brings us to another important aspect of the UK legal system that we haven't touched on too much yet. Equity.
Right.
Yeah.
Equity.
Yeah.
The conscience of the law, as they say.
Exactly. Because sometimes applying common law strictly, based solely on precedent, well, it could lead to results that just didn't seem fair.
So equity was a way to address those situations, when following the letter of the law didn't really achieve justice.
You got it. Imagine, for instance, you have a contract between two people, and due to some crazy unforeseen circumstances, enforcing that contract literally ruins one of them.
Okay, yeah, like something that was completely unforeseeable when they signed on the dotted line.
Right. Common law, with its emphasis on precedent, might have left them with no options. But equity, it could offer a solution.
So what could they do? Would they just tear up the contract and tell everyone to try to be friends?
Not quite. But they could adjust the terms of the contract, make it fairer given the new situation. Or, in some cases, they could even stop the contract from being enforced altogether if it was just totally unfair to uphold it.
So equity was like this pressure valve for the legal system, a way to release some of the pressure when things got a bit too rigid.
That's a great way to put it. And the amazing thing is, over time, equity and common law, they actually merged, became the single system we have today in the UK.
That's fascinating. So when we talk about UK law, it's this blend of tradition, precedent, and this idea of fairness baked right in.
Exactly. But even with all this, even with equity and judicial precedent, we can't forget about Parliament.
Right. They're the ones with the final say, ultimately.
Exactly. They're the ultimate lawmaking authority. And while judges play a vital role interpreting, applying the law, they are bound by the laws Parliament passes.
So even if a judge personally disagrees with a law, tough luck.
Well, they can interpret it, try to understand the intent behind it. They can apply it to new situations, like we've been talking about, but they can't just ignore it. They can't declare it invalid.
It's that balance between what judges can do and what Parliament decides that makes the whole system work, doesn't it?
It's a delicate dance, but it's what gives the UK legal system its stability and its adaptability. And that's what makes this relevant to everyone listening, even if you're not a lawyer or a judge.
Because, let's face it, legal history is fascinating, but it also has real-world consequences for all of us.
Every contract you sign, every time you get behind the wheel of a car, even just walking down the street, you're interacting with a system that's been shaped by centuries of legal thought.
Mm.
And this system, as we've seen, it's not static.
It's constantly evolving, new cases, new interpretations of old laws. It's almost like the law itself is alive in a way.
And that brings us to our final thought for you to consider. If judges can interpret laws in a way that essentially creates new legal principles, how much power do they really have compared to Parliament? Is this a good thing? Does this back and forth, this constant interpretation, lead to a more just society? Or does it sometimes create inconsistencies and uncertainty in the law?
It's something to think about, especially as we all navigate this complex legal world we live in.
It certainly is.
Well, this has been a fascinating deep dive into the world of judge-made law. Thanks for joining us.